Good morning, everybody. My name is Chad Heinrich, and I'm your state director for NFIB. Very pleased to welcome you to today's webinar on learning how to protect your business from COVID liability lawsuits. Before we get started, just wanted to go over a couple housekeeping items. First, I want to let you know that the meeting is being recorded. And so I'm sure you'll be taking some notes during the meeting, but just know that eventually we will be posting this on our website with a summary of the meeting, and we'll make that available to you and all of our members. So you'll have that as a resource moving forward. The other thing I'd ask is just to make sure that you're muted during the presentation. And also we'll have plenty of time for questions that you can ask either in the chat. If you want to use the chat box to put a question in, we'll get to that when we break for questions. And also we'll be open to questions through Zoom. So if you're familiar with Zoom, you can click on the reactions link and raise your hand if you'd like to ask a question through Zoom. So with that, I'm pleased to get started and let you know that one of our top priorities this year has already been signed into law, and that was Senate Bill 1377. And this legislation actually protects businesses from undue litigation as a result of the pandemic. Small businesses, NFIB members, had this as a top priority as we were moving through the pandemic, and we took this legislative session as an opportunity to work with several stakeholders to get this legislation passed. And we think it's important for you to understand what exactly the new law means. So today we've put together a panel of experts that'll help us understand really how to remain in compliance with the law, how the law protects you and your business from potentially frivolous lawsuits, and just give you some tips on how to handle future guidance changes as we continue to reopen and move forward. Again, just a reminder, you can click the chat icon in Zoom, add your question in there if you'd like to type that in, or as I mentioned, raise your hand and we'll get to you when we pause for questions. First on the introduction list for me is a real champion of small business at the legislature, and he's been a great friend to me personally and a great friend and advocate for small business, and that is Senator Vince Leach. Senator Leach has represented Legislative District 11 since 2018, and he was previously in the House for 2 terms. I'll tell you that he is very passionate about public service. He's been involved as a citizen activist in many areas of government, including school board, county government, the Arizona Corporation Commission, to name a few. I'll tell you, one would be very hard pressed to find another Arizona state legislator who works as hard as Senator Leach does on behalf of the taxpayer. In 2020, NFIB recognized him as a guardian of small business, which is a coveted award for those legislators who not only vote correctly on small business issues, they actually take a leading advocacy role by championing issues important to small business and getting the legislation passed. And of course, 1377, Senate Bill 1377 is an example of that. We're excited to hear from Senator Leach this morning as he shares an overview of why it's important to small business. And with that, I welcome your comments. Senator Leach, good morning.
Morning, Chad, and thank you very much to you and NFIB for the opportunity to share a few comments. Let me start by saying thank you for that opening. I hope I can live up to it in the next several minutes. It's really fun when you work for small business, when you work for the taxpayers, and that's has been my goal since coming up here in the House of Representatives. I was elected in 2014, came up here in 2015. The panel of experts that Chad referred to will follow me. I'm just I'm a senator, but I'm really a small town boy that thinks that there should be some things done. I've tried to do that in my time here, both in the House and the Senate. Specifically on 1377 and the COVID liability bill, what I would like to do in my minutes available, because following me, Don and Mark will give you the how-tos and the whatnots and where's this and where's that, and actually folks that helped me craft this piece of legislation. But this, just a little background on this piece of legislation really started getting put together over a year ago, actually March, April of last year. You may remember that there were two competing bills with the shortened COVID season and the COVID session. Neither one of them got across the finish line. Some thought they were competing bills. I thought they could be put together, but in any event, we didn't address the concerns of businesses, small businesses, reopening in the face of pandemic. What was their liability exposure, and how could the state assist and or help in that particular area? When session ended, a number of us started, with NFIB being one of them. We started on a path that led us to the finality of 1377. But it was, I don't want to say arduous, but it was a very eye-opening, full discovery of what we were up against, what businesses were up against, and how we could mold something into a piece of legislation that would be pinpoint enough to help everybody, yet broad enough that it was pretty much inclusive as we go about. And I think Don will talk about that just a little bit later. And so we started on down a path of, really it started with a few stakeholders. Chad was involved, and some of the other chambers. It started off as just a small discussion, and it continued to grow until I think at the end we had 80 some people that I know of, 80 some groups represented, that came to us through Chad, through Don, through Mark, and brought us ideas. So let me just tell you what 1377 doesn't do. It doesn't protect bad actors. And when I say that, we put it together. At first, we started with guidelines from CDC, and that became problematic, talking with stakeholders all the way along, because as we know, and still know, CDC changes their rules, regulations, and direction, if not daily, if not hourly, sometimes almost daily, and certainly weekly. And so it became problematic to tell small businesses, this is what you should base it on as far as COVID liability protection going forward. And so we changed our direction a little bit to the business side. And if you are responsible, if you're doing certain things, that Don and Mark will point those out, that is the target of what this bill tries to do, what we think it does. The relief started, the relief is only provided temporary relief until December of 22. I will say that we were in negotiations. Unfortunately, we did not get this out with bipartisan support. We thought that there should be bipartisan support from the Democrats and the Republicans. It turned out to be a straight party line vote. That's somewhat disappointing to the sponsor, and somewhat disappointing, I know, to all the stakeholders, because I think businesses, and small businesses in particular, don't know left, right, Dem, Republicans. You get up every day, you go to work, you put your money, your hours in, and you try to run a business for the betterment of your business, your family, and your employees. But it did come out, and we cleared the Senate, went over to the House. We had to make a couple of last minute adjustments because there was some concern on the part of AARP on one of the portions of the bill. We thought it was covered, had to do with long-term care facilities. We did make that change, and we came out and had our 31 votes to come across, and got it to the governor, who signed it. This not only, Chad, you said it was on your list to accomplish, it was also on the governor's list, and he mentioned in the I was simply the person pulling the plow. It's people like Chad, people like Don that you're going to hear from, people like Mark that you're going to hear from, that brought the ideas. And I just tried to, I'm not going to say because they're all of them good friends. It wasn't like herding cats, but some days it felt like that because we were getting so much input. But we have a product that we think stands tall, will stand tall with the other somewhere around 27, 28 states. The one thing that I will address before I turn it back to you, Chad, is that we always heard through the process, we don't think we need the bill, particularly from the other side. We don't think we need. Where is this? Well, there is a company that I follow. It's called Hunt and Andrews, and they actually track COVID-19 complaint tracker. And the last time that I checked, we had 103 open cases in the state of Arizona. There's like 1,400 across the state, and some $35 million has been spent already in setting the stage for additional lawsuits. It was a sorely needed bill. I thank everybody, and if your members, any of your members had particular input, I want to thank them. Chad, I want to thank you for just keeping us on target, getting us across the finish line, and happy to be a part of it. A small part of it. Thank you for having me on this morning. Now, you're taping this, right?
We are.
So I want to say what they always say in DC. I want the opportunity to revise and extend my remarks.
All right. That's always an opportunity you have, Senator.
Okay. Thank you, Chad.
Thank you. Thank you very much. Well, and I think it's really important to understand that this is a priority that NFIB has had in several states. But I will say that just reflecting on one of Senator Leach's comments about where the basis of the guidance comes from is really important, and that's I think something that we'll get into as Marcus and Don walk us through the legislation and how much, in my opinion, this is one of the better pieces of COVID liability legislation that's been passed in the country. And I just want to recognize Senator Leach for really, as he mentioned, pulling the plow, leading the stakeholder process to get us to that point. And so with that, I do want to introduce Don Isaacson. And Don is president of Isaacson Law Firm. He's been a longtime friend of mine, a mentor of mine. Don has been active in legislative matters since 1975 and has served in the capacities as Rules Counsel, Majority Counsel, and Director of Research for the Arizona House of Representatives. He began representing clients in the private sector on a regular basis before the Arizona legislature in 1986 and has been regularly and continually involved in legislative representation since that time. Don's going to highlight for us what businesses need to be aware of regarding Senate Bill 1377. And I do believe he has just a few slides that'll give you an outline of his talking points. Don, welcome and good morning.
Good morning, Chad. Good morning, NFIB. I want to join Senator Leach in congratulating and thanking NFIB. From the earliest days in discussing this bill, Chad and NFIB were present and helped shape it so that it would be protective for small business. And it was a key part of getting this bill through as well. Also, a comment on Senator Leach. I think, you know, a lot of bills start in January and at some point they pass and they're done. Senator Leach began this not this year, but actually last session in the 2020 session, and had an idea and a view of liability protection that was necessary and advanced it. Unfortunately, and maybe fortunately, the 2020 legislation did not pass. There were conflicting views, but Senator Leach picked up the issue and worked it and led the effort all during the interim until the introduction of 1377, and then began the hard work of securing vote by vote. Why is it difficult? Anytime you are going to limit somebody's liability against lawsuits raises significant issues for trial lawyers and others. And so there's an immediate pool of opposition. Senator Leach wove in and out and cobbled together the sufficient votes in both the Senate and the House to get it passed. So kudos to Senator Leach for his great leadership on the bill. I want to recreate the setting that existed last year when on January 31st, HHS issued a public health declaration of emergency because of COVID. And March 11th, our governor issued a state of emergency due to the necessity to prevent, respond, mitigate the spread of COVID-19. And we have been in the COVID world ever since then. The governor, rightfully so, early on acknowledged that there are liability issues and issued an executive order proclamation that on its face protected healthcare workers from lawsuits in encouraging them to work and give them protection at the same time. It pretty quickly became understandable that not only health workers, but that the basic business, the fabric of the community had to be protected as well. The healthcare industry certainly needed protection, but so did people who worked at Target and grocery stores and others serving the public. Many of you are in that role. And it became evident to people like Senator Leach and others that you needed protection too. It looked like it was going to be an easy liability situation where trial lawyers would find reasons to file lawsuits that a business or a particular institution failed to protect their customers and therefore spread COVID. And by March or April of last year, the effort was underway to find a way to protect businesses and others in this state. We did not have vaccination, and as you know, that there were conflicting CDC guidelines. We did not have any clear guidelines in the state that stayed in place. They were evolving: mask, no mask, 2 masks, distance, 6 feet, 12 feet. How is a business or how is anyone going to comply with that? Issues of capacity, distance, sanitation, keeping employees at home, having temperature checks on employees and customers. All of that was a swirling mass. So out of that came a recognition that there had to be protection, not only for healthcare workers, which for sure had to be protected, but for everyone as well. Nicole, if you could go to slide 2, please. So what does the bill do? The bill has 2 distinct parts. One part protects you as general business and everyone else. It's very broad, and it's designed to provide protection to someone who acted reasonably, and I'll talk more about that, to protect their customers and others from getting COVID. The other part of the bill is much more specific and is directed toward healthcare workers. And I know we have some healthcare interests on the participating today. So if you go, Nicole, to slide 3, why is it needed? It's needed for that specific purpose, that to allow commerce to continue and to reward, if you will, those people who stayed with providing business and services, educational institutions that continued to provide services through COVID. And so the bill, the first part of the bill is what you might call premises liability. And in order to be protected, here is the standard. A person or provider that acts in good faith, that's one element, good faith, to protect a customer, student, tenant, volunteer, patient, guest, neighbor, or the public from injury from the public health pandemic is not liable for damages in civil action if certain things have happened. Number 1, unless it is proven by clear and convincing evidence that the person acted or failed to act and the action was due to that person's misconduct or gross negligence. So you, in your exposure to potential claimants, customers and others who said they got COVID at your establishment, would have to prove that you failed to act and that your misconduct or gross negligence led to a person getting COVID. It is a core principle that has been set forth in other Arizona statutes at least 25 times, maybe as many as 30, where the legislature has protected conduct and has said, if you have exercised good faith, and if you have not engaged in any intentional misconduct or gross negligence, which is willful disregard, you are protected. So if you're listening today, and this is the first time you've heard this, if you haven't acted improperly, and if you have acted reasonably and responsibly, you are probably okay. And you probably have a defense against a lawsuit, and better yet, you probably will not have a lawsuit or a claim filed against you. You can show good faith, and there's a presumption that you acted in good faith if you adopted reasonable policies related to the pandemic. What does that mean? It's individual, and you always can show what you did to protect others. It's not a formula that you have to follow some specific guideline. And as you know, there were multiple CDC guidelines, there were Department of Health Service guidelines, there were governor executive orders, there were orders by the city of Phoenix, and in some cases, counties issued orders. I don't know how anyone could have kept up with them, kept them straight, and followed them to the T. And you are not required to have followed those to a T. You're required, in order to protect yourself. And by the way, although I've said past tense what you did, this goes forward as well, because we're not done with COVID. There may be another round, another resurgence of COVID. So what I'm talking about is not only your past conduct, but your conduct today and tomorrow. So what are the variables? Variables are masks, whether to require masks in your establishment or whether or not, for employees or customers. Distance, do you maintain, and did you maintain distance limits? Did you have capacity limits? Did you reduce capacity so that people were not on top of each other in your office setting or in your business? Sanitation, what did you do on sanitation? What did you do on temperature checks? Did you keep sick employees at home? Did you post signage telling anyone who had any sickness at all to stay away from your business? Not one of those is required, but those will all be variables in any claim and in any defense in a lawsuit. And so you will be judged on whether you acted reasonably. No specific conduct is required by this part of the bill, and you will be allowed, and you are allowed, to show that you acted reasonably and responsibly. The bill in its verbiage protects a provider and any other person. We could have gotten by in using the words any other person, because we did intend to protect everybody against a claim from anyone else that you gave them COVID. But in order to clearly send the message of the scope of protection, here are the named individuals and groups who are protected by this. But remember the words "or any other person." So a person who furnishes consumer or business goods or services or entertainment, that's a lot of you. An education institution or district, a school district or charter school, a property owner, property manager, property lessor or lessee. Do you have an apartment complex? Do you rent out a duplex? You're protected. A nonprofit organization, a religious institution, this state or an agency of the state, a local government or political subdivision of the state, a service provider, a healthcare professional, and a healthcare institution, and quote, any other person. So essentially, everyone is protected by this bill against a claim by someone else that you got them COVID. You created a condition where they would get COVID. You are protected as long as you acted reasonably. Could you go to, Nicole, to slide 4? A second distinct part of the bill relates to healthcare providers. And I know Mark will talk more about this, so I'm going to touch on this. It again requires that a healthcare provider acted in good faith and did not engage in willful misconduct or gross negligence. So the same basic standard, good faith, trying to do the right thing would be the lay term for that. Willful misconduct, I think we know what that is, some type of intentional act. Gross negligence, that is the same standard, but it is specific for healthcare providers. And healthcare providers have really two protections. One is anything they did in serving a patient, in protecting the patient, evaluating the patient, they are protected in the same way if they acted reasonably. But they're also protected, and to you healthcare providers, in what you did not do. In many cases, hospitals, other medical institutions, nursing homes, etc., had to divert care from healthy individuals or less sick individuals to immediately respond to COVID. And so in the case where care was not provided, nursing care was not provided, medical or hospital care was not provided, you're protected as well if you acted reasonably and good faith. This part of the bill also has a difference in that it provides a safe harbor. What is that? That is if a medical practitioner or a healthcare institution can say, I followed CDC guideline 304 on this issue, on sanitation or on medications, they are presumed to have acted reasonably. So there is a safe harbor for medical providers and healthcare institutions. That is different than what exists in general liability, where I said there is no specific standard. All you have to show is, among all the variables, you acted reasonably. Senator Leach mentioned a item that was added toward the end with respect to nursing care institutions. And as you know, nationally, nursing care institutions were criticized in some cases for the number of deaths and illnesses that occurred. Obviously, people in those circumstances were frail, and the bill required an addition at the end that said if a nursing home or other care institution was sued for failure to provide care, the burden on them in the lawsuit is to affirmatively show that there was a lack of staff, resources, or equipment. So the bill still provides to nursing care institutions and other care institutions, but it's a little bit tougher for them if they're saying we didn't provide care because we shifted our care to COVID. Not only do they have to show that, it's on them to show specifically lack of staff, lack of resources, or lack of equipment. I don't want to take any more time. I want to give time to Mark to discuss the medical component, but also to discuss, I know he wants to discuss the practical effect as well from the point of view of a school district. Thank you.
Thank you, Don, for giving us the overview on the most important factors I think that small business owners need to be aware of. And I like the way that you framed it, because it kind of goes back to the high level viewpoint that we shared with lawmakers when this was going through the legislative process. You know, what we want is, we want to know that we want our small business owners to have confidence, right? Confidence that if they are acting in good faith, just as you outlined, that they are going to be protected, confidence that they can open their business and know that they have this safety, this safety net and this protection available. Know that they have that between both their customers and their employees. So I think that's very important, and I'm glad you highlighted really the framework behind the legislation. Now, I'm sure folks are wondering how to stay in compliance with this new law moving forward. And I'm really glad that we have some important tips to share from Marcus Osborn. Marcus is the Senior Government Relations Director for KutakRock. And Marcus has over 20 years of state government relations experience and has really worked in a wide variety of high-profile issues throughout those years, including significant changes in Arizona's environmental protection laws, regulatory reforms, tax structure changes, and employment laws. Marcus is going to share some tips on how to remain in compliance with this new law. So Marcus, thank you. Good morning, and go ahead and take it away.
Well, thank you, Chad, and thank you, Senator Leach, for sponsoring the bill, and thank you, Don, for your great presentation. What I'm going to try to do is kind of focus on how to kind of blend your business practices with mechanisms to make sure that you're protected. Now, I think if you ask the insurance industry, and that's who I primarily represent, the biggest fear from COVID lawsuits, or similar to what you guys faced during the ADA lawsuit crisis, is these kind of drive-by lawsuits where certain plaintiff attorneys are hoping that the cost of depositions and legal filing will result in settlements. And so the legislation was carefully crafted to kind of create a very high bar for plaintiffs to go after businesses. So I think the first thing to be very clear is this is not an absolute bar of liability. It's not a get out of jail free card, but it's a very high standard. I think one of the key things to note is if you get sued, your insurance liability policy will have provide for defense of your business. So how do you work with them so you have coverage for these type of lawsuits? Second question I always get asked is, does the bill change workers' comp liability? And the answer to that is no. If an employee gets sick on the job, they may be eligible for workers' comp. However, generally speaking, in a pandemic, it's very difficult to demonstrate that the workplace illness occurred on the job. Now, I think there's some broad exceptions of that, mainly in the cases of healthcare workers, first responders. But even then, it's very common for these not to be covered. I think employers who have smart and reasonable leave policies during the pandemic, I think are going to be in the best position to protect themselves. Making sure that employees do not feel pressured to go back to work when they're feeling the slightest bit sick. That will also generate, I think, enhanced productivity, and you won't end up having to have employees go home because they have to quarantine. That's probably becoming less and less of an issue with the higher vaccination rates. But I think the employers who have those more generous leave policies and treated their employees as professionals tended to do better in terms of shutdowns and other things. And that's a good demonstration that you're operating in a thoughtful manner. Requiring employees to go to work while they're sick, I think that's when you start looking at exposure under that gross negligence standard. So those are things I think you should avoid. I think as a general philosophy, if you do things that make your employees and your customers feel comfortable in your facility, that's the best way to kind of meet those standards. Because I think what you'll probably found during the pandemic is that customers want a certain level of protection, employees want a certain level of protection. And as long as you're following those reasonable approaches, that mirrors in with a good business model, And now the challenge is, as we're starting to become in a much safer position, you can start peeling those back. Now, one of the key things in terms of compliance is document what you're doing, and make sure that you keep good records. And it could be things like simply saying, putting a note in your file, I consulted the CDC, the state, whatever website for the updated guidance. Things that you probably wouldn't normally, kind of keep records, but keep those as a good kind of file, so that in the event that you get sued, you can go in and say to your insurer or whoever is defending your claim, look, I checked these, I looked at these things. And as Don said in his comments, none of the CDC or state health or any of the guidance was so prescriptive. It gave you some options. And as long as you consulted, were thoughtful about that, and picked the options that worked for your business, you're going to be fine. You're going to be protected. And so just keep that documentation. Secondly, in many cases, your carrier, whether it's your workers' comp carrier or your liability carrier, will also give you guys some guidance or other things that kind of help, or even help you document that. So a lot of the carriers have started to do those type of things. Now, one of the other big questions that I get is, should I mandate that my employees get a vaccine? Very controversial topic. And I think the advice that we are giving as a firm right now is, at this point, no. And there's a couple of reasons for that. The first one is that all of the vaccines are on a temporary or interim approval. And so even the hospitals and a lot of the healthcare institutions are making the vaccines voluntary until potentially you get final CDC or FDA approval on those vaccines. The better approach is to encourage, incentivize, all those normal things. And all health insurers are mandated to provide the vaccines for employees or individuals for free, no out of pocket. So there should not be a cost issue. Second issue that folks always ask about is, well, a lot of the cities have various mask mandates and other requirements. Are you required under Arizona law to enforce those mandates? And the legislature stepped in and said, with House Bill 2770, that no, businesses are not required to be the gatekeeper or the regulator, because that's not your role. Now, you have every right to control what happens on your property. You have every right, and especially in the pandemic, to say, if a customer is not willing to follow what you want to have occur on your property, to ask them to leave. I think you have even more protection for doing that. And so I think those are things that you need to look at and consider. Other pieces of advice during the pandemic, the liability protection, one, the good news is it's retroactive to the beginning of the pandemic. So if you're worried about exposures back to the beginning, you are protected. This heightened liability protection only lasts to the extent that the governor has his state of emergency, the health emergency mandate. So there is going to be a period where COVID is probably still around in the community, but not at as high of a level. So I would continue to keep those practices, even in the post-COVID mandate, not meaning the masks and all those things, but documenting, demonstrating that you are following and looking at best practices. And then eventually when COVID goes away, you can return to more normal. And I'm mainly looking at that in terms of a record keeping and those type of things. That way, if the state of emergency goes away and you get some exposure, you're still protected. Lastly, I'll just kind of give you a little story about how challenging this is, and I happen to have the unfortunate honor of being on a school board during COVID. And not only was it a challenge to get kids back in the classroom, but we found out that we had to get a special liability policy just to cover COVID claims. And that policy, just for our little tiny school district of about 5,000 students, was about $70,000 a year in terms of additional protection. And the good news is, now that this law is passed, we got our premium renewal for the following year, and that's dropped down to $35,000, and it's potentially refundable. But the reason why I mentioned the story is, if you look at a school district not unlike a business, we have Maricopa County, who has reopening guidance that is different than the state guidance, that is different than the CDC guidance, and it's different than what the board wants to do and what's actually practical. And so all those things, what we've done at the district is make sure we've documented our approach, be transparent about our approach. And by doing that, now we've met those standards in place that, we have acted in a reasonable manner, and can handle that in that fashion. So those are some kind of guidance tips. The last thing I will mention is, some states are going down, I think, a very troublesome path, and I'm going to use Oregon as an example, where they require businesses to verify if someone's going to be unmasked in their facility that they have a vaccine. Now, I know that's not an approach that Arizona will take. You do have the right, if you want, to limit who gets in, masked or unmasked, with vaccines. The vast majority of businesses that I've talked to said that's such an unworkable strategy that they're not pursuing it because it creates so much potential conflict with consumers. Just be reasonable in your approaches and you'll do fine. And I'm very glad that Arizona is not going to go down that approach in terms of mandating businesses to allow unmasked people to show a vaccine card. I think that is just a recipe for disaster. And with that, I'll be happy to answer any questions along with the group.
Thank you, Marcus. Really appreciate that overview, and I'm glad that you brought up the other legislation that really helps to protect business owners from being the mask police in case of any local requirements for mask wearing. One question that I'd probably just start off with is, from Don and Marcus, from your perspective, let's say I'm a small business owner and I get served. I get served a lawsuit in this area. Who do you think I should call first? Like, who's my first call? What should I be doing as first steps if that happens?
Well, I think you call your insurer for sure, and you let them know, and they will provide you advice, and that they're going to expect that if there is a claim that you have notified them as early as possible. I think, to Marcus's point about records and to put the situation back and document what occurred. The claim is going to be in reference to a particular event or time period. So you start immediately reconstructing that time period. Anyway, I think as other claims, your insurer is first.
Yeah, and a lot of the policies will have coverage for defense costs and things of that nature. So get the claim process started. If you need to secure your own counsel, you can do that, but make sure you understand the terms and conditions of your policy, what you'll be reimbursed for, or will the insurance policy cover these claims? I think what you'll see is a lot of these cases, they're gonna try to see if there's a settlement and kind of try to bully you into the cost. That's why looking at your insurance coverage and making sure that those legal defense costs are covered, because I'll tell you, I think the general position of most of the insurers is going to be to fight these cases, because if it becomes a a pattern of, hey, XYZ insurance company always settles these to keep it out of court, that is going to beget more cases against that insurer. The trial lawyers know who's going to settle. And back to Don's point, by having that documentation already prepared, just in your file, then you're much better prepared. You're not scrambling, trying to recreate, files and things of that nature. We're pretty optimistic that these national trial groups are going to look at Arizona, look at the high burdens and say it's much easier to go into some of the blue states that did not pass liability reform and focus their efforts on those states and fly over Arizona. As Chad knows and Don knows, when we tighten up the ADA statute and made it a far more reasonable, a lot of those drive-by lawsuits went away almost instantaneously because we created reasonable barriers. And then the cases that you do see are probably much more likely to be true ADA violations. We anticipate the same thing occurring here. I think the other area that you may see some litigation is on employment disputes and employees coming back to work, not wanting to come back to work, and whether or not you're treating them with reasonable accommodations. I think the one thing that I would be very focused on in terms of can I make my employees come back is look in particular for those employees who may be immunocompromised, look for some ADA accommodations for those type of employees. But other than that, I think you can, when you're ready to have your employees fully staffed, but still you may want to take some of those mitigation measures and then over time as COVID dissipates, ease them up. It's much easier to start a little bit more aggressive and ease back than it is to try to put in additional restrictions. So those are some other thoughts I have in terms of on the employment side.
Chad, could I ask Don and Mark to follow up on an extension of your question? And
Yes.
that is, we're in May, almost June of 21. This will run through 22. Don't let your guard down as we get further away from March of 20. And Mark and Don, if you have any further comments, and I'm referring to the statute of limitations cases that we've had in Arizona that we're going to see potentially a year out. We may see a spike of sorts. If you care to address that,
I'd be glad to. The way the bill is written, if an action, a complaint is based on facts today, you're protected forever. And so worst case scenario, a child is in your business and later, when they're 14, 15, whatever, develop some disease and it's attributed back to COVID exposure, you would still be protected. This intends to protect you from the actions today forever. So that part you're covered. But I do want to talk about a couple other points just to emphasize, and it does not cover workers' comp claims. Mark touched on that. Workers' comp, the relationship between employees and employers is a no-fault system of claims and payments and evaluations. So this really deals with others than employees. So remember that. It also doesn't deal with contract claims. And during the formation of the bill, there was some interest in saying for contract non-performance during COVID, this should apply as well. The bill clearly does not cover contract claims, but there is in the contract world a principle that's well established called force majeure. And if two parties enter a contract for supply or for services, and what prevents a party from fulfilling that is something that neither expected, and it was a major force like COVID, the party who has the obligation to perform is relieved of that obligation. So in common law for contracts, what we are doing here in civil law already exists in basic principle and contracts. So this does not cover contracts. To Marcus's point and emphasize going forward, who knows what's going to happen with COVID? There are estimations that we're going to have new waves and new strains. And so the protections which we are talking about today, keep in mind as there are new CDC guidelines and new mask requirements, that you act reasonably and responsibly and document what it is that you have done. Anyway, back to you, Senator.
I'll turn it back to Chad for any questions from the guests online.
Thank you, Don. Thank you, Senator. Yes, I'd encourage anyone that has a question, go ahead and unmute yourself and ask. We're getting close to our time, so we want to get any questions in that you might have. Doesn't look like we have any questions. You know, Marcus.
Yeah, there's one little piece I want to add in terms of just because the pandemic is over, I would still recommend keeping your records because there is, you know, plaintiffs do have a time frame. And Don, I can't remember, is it 1 year or 2 years in which they can file an action during that period? But just make sure you keep your records for whatever that statute of limitations is on terms of filing cases, just to be safe.
Good advice.
Well, very good. Thank you, everybody. We are running out of time for today, and I really appreciate Senator Leach, Don Isaacson, Marcus Osborn for leading us through the discussion today. We appreciate each of our members joining us today, and as I had mentioned at the beginning, we do have this recorded, and we'll post it to nfib.com/az. That's the home for all of Arizona's activity related to legislation, related to this webinar, all kinds of resources out there. And so you'll be able to access this webinar, you know, in perpetuity. And with that, again, thank you for everybody attending. And until next time, appreciate your participation and your membership in NFIB, and have a great rest of your day. Thank you.